Bloomberg Audio Studios.
Podcasts, radio, news.
This is Bloomberg Law.
What does a prosecutor have to prove in order to get a RICO conviction? Tell us why the Solicitor General is sometimes referred to as the 10th Justice.
Interviews with prominent attorneys and Bloomberg legal experts.
That's Jennifer Kay for Bloomberg Law.
Joining me is former federal prosecutor Robert Mintz.
And analysis of important legal issues, cases, and headlines.
Is the toughest hurdle for prosecutors proving Trump's intent? Alito took on Congress, saying Congress has no power to regulate the Supreme Court.
Bloomberg Law with June Grasso from Bloomberg Radio.
Welcome to a special edition of Bloomberg Law. I'm Amy Morris, in for June Grasso. Now, this year saw a number of high-profile antitrust cases. So ahead on this show, we're going to take a look back at some of the big ones, including the blocked merger between Albertson and Kroger, and the failed tie-up between luxury brands Capri and Tapestry. We'll also look ahead to what President-elect Donald Trump re-entering the White House could mean for antitrust regulation moving forward. All that on the way on this special edition of Bloomberg Law. Now, what we're going to start with is non-compete employment agreements. For decades, they've prevented all sorts of workers, doctors, engineers, hairstylists, and journalists from easily just switching jobs. The Federal Trade Commission approved a near total ban on these non-compete clauses, but then that got blocked by a federal judge back in August. The judge said the FTC did not have the authority to do this. Professor Spencer Weber-Waller is director of the Institute of the Consumer Antitrust Studies at Loyola University Chicago School of Law and joins us now to bring us up to speed on what this means. Professor, I want to thank you for your time and explain about this block of what the FTC's proposed rule was. The judge called it arbitrary and capricious, but supporters say that if you force workers to sign a non-compete, that does harm to them.
Well, sure. I'm thrilled to talk about this. I can't get into how the sausage was made. This was one of the projects that I worked on in 2022 as a senior advisor for the Federal Trade Commission. But the idea is that these are very harmful for workers, and particularly in low-salary workers where there's really no serious question for a sandwich maker or a security guard or home healthcare worker about know-how or technology or that sort of thing. And so the FTC was engaged in a long-term project, research, reports, conferences, and eventually the writing of an administrative rule that was released to the public for comment and revised and kind of toned down a little bit. Final rule was issued earlier this year, and there was some litigation. And it's a little more complicated. There are three different cases. The FTC won one of those in Pennsylvania and lost two in the Deep South, one of which it resulted in an injunction. So the rule hasn't gone into effect. I don't think this is over. I think it's going to go to the Court of Appeals and conceivably the U.S. Supreme Court. At the same time, the FTC has also brought cases where it has the power to prohibit an unfair method of competition, either in litigation or in rulemaking. These cases only deal with the rulemaking. There have been at least three cases that I know of where the FTC has challenged companies' behavior in a particular industry as just unfair in keeping workers' wages and mobility down. And the courts have, in each case, the defendants have settled, and those are binding rulings now on those defendants. But the rule is the bigger deal because it would apply nationwide to most industries and most non-competes.
Now, this is under the FTC's purview, is it not? If they can't come up with this rule, then who would?
Well, there's a tiny number of industries that are just not subject to the FTC's jurisdiction, things like airlines and other regulated industries. But the FTC is the main but not the only consumer protection and antitrust agency. The Department of Justice litigates, but the FTC has the power to do both litigation and rulemaking. And this is about the rulemaking power. It is not the only, but it is one of the rare times the FTC has issued a rule relating to their antitrust, not their consumer protection powers.
I wanted to ask about that. This doesn't happen very often with the FTC, and these non-compete clauses have been in effect for decades. Where's the FTC been on this before?
Well, the FTC is one of a number of actors that has looked at this. State attorney generals and state legislatures and the U.S. Congress have looked at these. There are 17 states or so that either prohibit them outright, like California, or impose conditions on when you can have a non-compete. In Illinois, there's a salary cap of about $100,000, where anything below that, a non-compete would be illegal. And what the evidence is showing is that even having these state rules just isn't enough. And if you want a uniform national treatment of this issue, the FTC is the logical place. Whether they have the powers to do so is what's being litigated in the federal courts right now.
Is this another example of sort of reining in power from federal agencies, wresting that from them?
That's hard to say. You're absolutely correct that the FTC has not issued a lot of antitrust, unfair methods of competition rules. That doesn't mean they don't have the power, but that is one of the issues the federal courts have to wrestle with in looking at this particular rule. I don't know the history of why past administrations didn't do it. I think perhaps they thought that it was better to proceed just on a case-by-case basis in general, rather than getting into a rulemaking proceeding. But I thought it was necessary and quite a good thing that the FTC did, and I hope it'll hold up in court. But, I don't have a crystal ball that's any better than anybody else at this point.
And it is interesting how you say how complicated this is, because it also put companies in a bit of an odd position. For a while, it wasn't really clear if the FTC was able to do this, if this was going to pass muster, if it was going to have to be shelved for a while. Employers were kind of in this mezzanine level where they didn't know if they were able to tell their workers that the non-compete was null and void, or if it was something that they could enforce. And so everything was in limbo for a while.
Well, and it is still in limbo, as this gets resolved. And so, what I understand, I'm not a labor and employment expert. I'm an antitrust and consumer law person. But my friends in that line of work are telling companies to be very cautious and not to use these unless they have a strong reason to do so. Do them more selectively rather than across the board, and be aware that there's some states that they're simply flat out forbidden, like California. And also that there's legislation coming in other states that's cracking down on this. So, companies are on notice, and the rule is just one aspect of how this is going to be regulated in the future.
I know you don't have a crystal ball. You said so yourself. But what does this say then about the future of work? How far can this go? What's likely to tee this up for Supreme Court review is if you get a split in the circuits. If you get, say, for example, the case in Pennsylvania where the FTC won. If the Third Circuit were to uphold that point of view, and let's say one of the circuit courts in the South were to find it's unlawful, and that's the kind of thing where the Supreme Court often weighs in. And yes, you're absolutely correct. They're not a fan of independent agency regulatory power, and the FTC faces a number of constitutional and administrative law challenges. The narrowest is that the agency's fine. Unfair methods of competition are fine. They're even fine if you use them in a particular case against non-compete clauses. But there's a narrow path where they could say you don't have the rulemaking authority to do this, but you do have the power to seek a individual case against an individual defendant. Problem with that is that's like playing whack-a-mole. Right.
You really, in all fairness to business and to consumers and to employees, a nationwide uniform rule is the best way to tackle this, in my view.
Okay, we're going to continue to watch that as it makes its way through the courts. Meanwhile, we're going to shift gears now and talk about big tech and Google. Antitrust enforcing, wanting the search giant Google to make some big changes, including potentially selling its Chrome browser. Now, Professor, Google says any remedy would allow competing browsers like Apple Safari to actually have the freedom to do the deals with whatever search engine that they think is best for their users. That's what they want to see happen. That's what they say should happen. The judge has said that it's illegal for Google to pay Apple to use Google's browser as their default. Does Google have a point here? Market freedom, free enterprise, that sort of thing?
Well, this is one of a number of, probably the busiest few years in monopolization law in my lifetime. And Google was the case that finished first, and it was a great victory for the government. Google was found to have monopoly power over different aspects of search, and that they violated the law by entering into those exclusive deals, paying the huge amounts of money that we've all read about. But they didn't obtain this monopoly unlawfully. At least the court didn't make any findings like that. But they did unlawfully maintain that monopoly. So you're right. Everything rests with the remedy. And this case follows in the footsteps of Microsoft about a generation ago, where you have a company that didn't do anything wrong but had a monopoly and then started doing lots of things wrong to maintain that monopoly. And the problem in the Microsoft case was that the court kind of lost its mind when it got to the remedies phase. It wrote a really terrific, lengthy, detailed opinion in the district court of why Google had acted unlawfully, why it had no pro-competitive justification or business justification for what it's doing. And the court back in the 90s, early 2000s, just rushed through a very short hearing on remedy, and also had done some other kind of outlandish procedural things. And they had originally said you have to split essentially the Windows operating system from the application software like Word and Office and that kind of thing. And the Court of Appeals just said, you rushed it, you did some other things wrong, we're only going to prohibit the specific things that you found were illegal. Not that much changed in the marketplace, and that's the issue before Judge Mehta in Google. Not just what did they do wrong and how do you stop it, but how do you deprive them of their unlawful profits from their illegal behavior, and how do you restore competition? And so I know I'm filibustering you a little bit, but the remedy stuff is absolutely key. And you have Microsoft as a roadmap for how to have a government victory that doesn't change very much in the marketplace. And I know the government and the court has that on their mind as they're deciding the remedy stuff right now.
It does seem like this is another example of the law trying to catch up with the technology.
A little bit. Antitrust litigation is backward-looking. In Europe, you have kind of more prospective legislation like the Digital Markets Act and the Digital Services Act. But here, where the court has judged that they acted unlawfully and maintained their monopoly in a way that goes beyond competition on the merits, and you have to stop that. And you don't want the Microsoft situation where the government wins, but not really that much changes. And I know the government has recommended the sale of Chrome or otherwise separating kind of the search function from the from the browser. And that's something I hope the court considers very seriously, because these behavioral remedies often don't work. The history of Microsoft is a history of really, really long periods of time where they were under court supervision. They did most, but not all the things that they were ordered to. And again, not much changed. They had to share lots of technical information so that competitors could better interoperate with them. That's going to be part of the solution here. But when you do structural remedies, it's cleaner. It's more painful for the company. But they're the ones who are held to break the law. This is not a criminal case. No one's going to jail. Nobody's being fined. The question is, what changes in structure and behavior are going to be enough to change take away the fruits of their monopoly, unlawful monopoly?
Professor, we're going to leave it there. Thank you so much for your time. It has been a pleasure.
Oh, thank you. I appreciate it, Amy.
Our thanks to Professor Spencer Weber-Waller. He is director of the Institute of Consumer Antitrust Studies at Loyola University Chicago School of Law. Up next, we take a look at the blocked deal between Kroger and Albertson and a few other big antitrust cases in the retail space. You're listening to a special year-end edition of Bloomberg Law. I'm Amy Morris, and this is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
This is a special edition of Bloomberg Law as we look at some of the big antitrust cases from this past year. I'm Amy Morris, in for June Grasso. Now, we saw several big merger deals blocked, including one that would have created a grocery behemoth. A federal judge blocked Kroger's nearly $25 billion acquisition of Albertson, saying that proposed tie-up would create a competition problem for shoppers. To take a closer look at the failed deal and the fallout for both grocers, plus a look at some other big cases in the retail space, we welcome Professor Peter Carstensen, Professor of Law Emeritus at University of Wisconsin Law School. Professor, thank you so much for taking the time.
It's a pleasure to be here.
Let's talk about this particular merger. The FTC blocked the deal, arguing that it would violate antitrust law. That was seen as an FTC win, of course, but then Albertsons sued Kroger. Walk us through how this worked.
Well, Albertsons got looted before it was sold. They gave up several $1 billion to their shareholders, so they're already impoverished, expecting that this deal with Kroger was going to go through. They now claim that Kroger did not really do the best job it could have in defending and justifying the merger, inadequate proposed divestiture, et cetera, and that obviously has harmed Albertsons enormously, and so they're seeking huge damages as a way of trying to get some funding back in place to restore themselves as a competitor.
Even though it was the FTC that blocked it?
Right. Well, up until this case, the FTC best of my present recollection, never actually stopped a grocery merger totally. It would say you've got to give up these grocery stores or those grocery stores. You propose to give up 120 grocery stores. We want you to give up 212 grocery stores. But they let the mergers go through. This time, they finally got the courage of my convictions and said no. They made a really stupid settlement, actually, with Albertsons a few years ago. They divested 150, something like that, stores to a company that almost immediately went bankrupt. And partly because the stores that were divested were the dogs in part of the Safeway empire. So that this time the Trade Commission said, no, we're just not going to approve the merger. There was something like 1,400 local markets where Albertsons and Kroger were significant competitors with each other. They were proposing to fix a significant number of those overlaps, but not all of them. And so this is sort of where the Trade Commission said, that's not an adequate settlement. First of all, this is a clearly anti-competitive merger in terms of those overlaps. And what you're proposing by way of a settlement simply doesn't solve the problem. Very good opinion by the judge, by the way. We've seen this year at least 4 really good decisions, 3 that I can think of from trial judges. This one, the one in the Google monopoly case, and the Tapestry and Capri case. All of them, the judges did really, really good jobs. And what the judge said on the settlement was it would reduce the number of markets where there are harms substantially if and only if the company acquiring these assets is actually 100% successful. If it has any failure, there are going to be more markets harmed, and this is a company that in the past has bought grocery stores and then sold them one way or another. So the judge said, this is really not a very good settlement proposal from Kroger. I'm not going back to Albertsons. I think this is why Albertsons is irritated that Kroger did not come up with a more credible buyer and did not offer more stores by way of a settlement, which made it harder to justify the proposed dissolution of justify the merger because of what was being sold off.
Well, so does Albertsons have a shot at winning this case?
This gets over into outside really of antitrust law, over into corporate duties. Did they fail to engage in good faith advancement of the merger? They're going to be saying something on more or less along the lines of, ours was a really good proposal. The judge just didn't accept it. It was as far as was reasonable to go, given how much we were going to pay for Albertsons, or words to that general effect. Mm-hmm. And so that's going to turn, and so it's in Delaware, it's in state court, it's going to turn on the duties of a buyer to a seller where there's some conditions. And that's above my pay grade to speculate. I would guess if Albertsons has some pretty good evidence, there'll be a settlement. Kroger will pay some more money to Albertsons.
Now, you mentioned Capri and Tapestry earlier in this interview, and that deal wasn't blocked, but they mutually decided to end the agreement after a court order froze them. Walk us through that decision. It sounds like it's not quite as contentious as the Albertson Kroger.
Oh, I think it was at least as contentious on what's called the market definition. These are high-priced purses that are in the popular high price or something like that. And the argument was a purse is a purse, and you can get a purse for $20 at Walmart. You can get a purse from one of these fancy folks for $1,000. I've been seeing some ads recently, and I keep asking myself, why would anybody pay that much for a purse? But it's not me. So they were seeking a preliminary injunction, as I recall, for the Trade Commission, so they could proceed. And the question was whether you could distinguish in this purse and other accessories world a domain, an area of competition involving this sort of middle price range from like $100 to $900 for purses, as opposed to purses that were priced $1,000 or under $100. And the Trade Commission put in some pretty good evidence of the way in which these two companies had specifically identified themselves as being in that zone of purse competition, accessory competition, and it identified each other as being their most major competitor. And so, again, the argument was, under the antitrust law, a merger which may, the word may, substantially lessen competition or tend to create a monopoly is unlawful. So it doesn't have to actually eliminate the harm competition, restrain competition. It simply is something that is reasonably likely to harm competition. And these two firms identified themselves as each other's primary competitor. There were other associated facts that really, in the judge's view and the Trade Commission's earlier view, really did create this kind of competitive zone where if these firms merged, there really would not be, they had 4 or 5 different brands as well, there really would not be other equally significant competitors in that band of purse and accessory supplies. The high-end producers, brand-named European outfits, would be unlikely to want to cut price to enter that area, and the low-price people have a very hard time, apparently, raising their profile. So that if you traditionally saw one of their purses as a $80 or $90 purse, for them to convince you that it's a different line but with the same brand name is really a $250 purse is apparently a very difficult advertising, promotion, credibility problem, so that the judge felt that there was good reason to believe that this merger would significantly affect competition in that domain.
Well, Professor, before I let you go, I'm curious about what this could mean for future M&A type deals. We've just talked about 2 really big ones that got frozen and got dissolved. Does this have a chilling effect on others who may be looking at mergers and acquisitions?
Well, I would so like that to be the case. Most of these mergers at this scale have no legitimate justification in terms of efficiency, product promotion, innovation. I think if the Biden-Harris administration had been retained by the voters, there was a reasonable probability that this would have had an inhibiting effect. What is very uncertain is with the new Trump administration, even though the designated heads for the Antitrust Division and the Trade Commission are actually pretty pro-antitrust, how active they will be in enforcing merger law at this level, certainly the market, the folks who are putting deals together don't think so. There are a whole lot of deals that are set to come forward after January 20th. And that would suggest that the market the investment bankers think that merger rules are going to be relaxed. A number of them were, of course, substantial contributors to the new administration's campaign and to its the inauguration, etc. And it is allegedly a transactional administration, which would, again, suggest that they may know something here.
Professor, we're going to have to leave it there. Thank you so much for taking the time with us. Our thanks to Professor Peter Carstensen for joining us, Professor of Law Emeritus at the University of Wisconsin Law School. Now, up next, we are going to look ahead to 2025 and preview how another Trump administration could impact the regulatory environment. You're listening to a special edition of Bloomberg Law. I'm Amy Morris, in for June Grasso. This is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
Thanks for listening to a special edition of Bloomberg Law. I'm Amy Morris, filling in for June Grasso, and we're focusing on antitrust regulations on this show. President-elect Donald Trump has promised to make some sweeping changes to government at the federal level. He'll inherit a record amount of pending antitrust cases. We get a preview now of how a Trump White House might be handling things. We bring in Bloomberg News antitrust reporter Leah Nylen. Leah, a pleasure. Thanks for joining us.
Thanks for having me.
Assistant Attorney General for Antitrust, Jonathan Kanter, leaving the agency, got a lot of cases pending. What's happening here?
Yes. So Jonathan Kanter is officially gone for the next couple weeks. His number 2 at the agency, Doha Mekki, is in charge. And then on January 20th, somebody from the Trump administration will come in. Donald Trump has nominated Gail Slater to take over the position. She is a longtime antitrust lawyer with experience at the other agency, the FTC. For the past couple of years, she has been working at a number of anti-Google companies, including Fox Corp and Roku, and she has recently served as the economic advisor to J.D. Vance. So she's very familiar with these lawsuits and has, lots of thoughts about how they could go forward. At the Federal Trade Commission, Trump has nominated one of the current GOP commissioners to take the chairmanship from Lena Khan, who is expected to step down after the inauguration. His name is Andrew Ferguson. He is a former Hill staffer for former Senate Majority Leader Mitch McConnell and has also served as the Solicitor General of Virginia. He has also a lot of anti-big tech views and has recently spoken about the need to look into the tech platforms over their censorship of conservative viewpoints.
Okay, there's a lot to unpack there, but obviously people are being moved into those positions or getting positioned to move in come January 20th. The next administration is going to have to be the ones that pick up the baton and move this forward. From what you know about these nominees, these people who may be taking these positions, is that something that they are inclined to do, or would they go a different direction?
No, both of them have already sort of made clear that they intend to move forward with these cases that have already been filed. And in his nomination announcements, Donald Trump indicated that he picked them in large part because of their views on tech. So yes, the Google case is sort of the first one, the biggest one that remains pending at the Justice Department. And there is supposed to be a trial on that one in April over what sort of conditions the courts may place on the company after it was found to be an illegal monopoly. The Trump administration will have a chance in March to weigh in if they have any views that are slightly different from the Biden folks. The Biden team put in a proposal for how they think the court should make some changes to Google's business. But as I mentioned, the Trump team can make some changes to that before this trial takes place in April. And then we'll go forward with a several-week hearing, and the judge has promised to issue a ruling before August of next year.
Now, that's Google, but there are also other cases. Ticketmaster, Apple, Visa. all accused of illegally dominating markets, and the Justice Department suing them. And plus, there's that monopolization suit against Google that you were talking about. Those cases are still pending. They don't even have trial dates yet.
Yeah, those ones are all sort of in the early stages. They were filed by the Biden administration in the past year, so they're very early. It's definitely possible that folks from those companies try and persuade the Justice Department to settle with them. That is, something that has happened in a lot of previous administrations. People often point back to the Microsoft case, which was started by the Clinton administration. And then after George W. Bush came in 2011, his administration opted to settle with the company. So it's pretty much guaranteed that the companies will at least make attempts to settle. Whether Slater and the Trump team are interested in a settlement sort of remains to be seen. But, they might be interested in seeing what the companies might be willing to offer up.
The Trump administration is known for being a friend of big companies, big tech. And I wonder if that is going to play a role in how he makes his decisions as to whether to move toward the antitrust type cases that are already pending. There's a question as to whether would he move forward with them.
Yeah, that's definitely a good question. Some of the CEOs of the companies have already sort of made overtures towards President Trump. Mark Zuckerberg donated a lot of money to Trump's inauguration fund. Tim Cook went down to Mar-a-Lago and had dinner with Donald Trump. And afterwards, Trump announced that any sort of trade sanctions that are imposed on Chinese companies would not apply to Apple. So it's definitely possible that there is going to be like this lobbying push to try and persuade Donald Trump to settle some of these cases. So that's sort of why they're all a little bit up in the air for, the next couple months. The thing about some of these cases, like the Ticketmaster case, for example, is they are like very unpopular with the public. So if he were to sort of settle that case, it's not going to make him a lot of friends with the average voter, but then again, he might not care.
I see. So where do you, since you've been covering this and you are the antitrust reporter for Bloomberg News, where do you see this headed now, and how long does it take to unravel these types of cases? Yeah,
if they do opt to take any kind of a settlement, we could see that by next summer. They're not just going to drop them, probably. They would want something in exchange.
Sure.
Either that's some kind of settlement where the company agrees to change some of its business practices, maybe pay a little bit of money. It sort of depends. In the Microsoft case that everyone keeps pointing back to because it's our sort of best example, Microsoft agreed to be under government supervision for the next 5 years. That ended up turning into like a decade-long saga. So,
right. That's
people
what
may
I'm
not
saying.
want.
It takes such a long time to unravel all of this, and also there may be more coming down the pipe.
Yes, that's certainly true. There are still a number of cases that both the FTC and the DOJ have been investigating into large companies for the past several years. Some of the health insurance companies, meat packers, all sorts of stuff in the sort of pharmaceutical and the pharmaceutical benefit manufacturers, the drug middlemen area. So, we could see more lawsuits, coming in the next year. All of this sort of depends on how the Trump administration really wants to play this issue.
And that's kind of a mystery at this point.
It still is a little bit of a mystery.
Because none of us have a crystal ball.
Definitely true. Someone once described Donald Trump's sort of method to me as saying, like, he doesn't get involved in, like, the policy details. He tends to delegate decision-making to a person that he trusts, and that person is sort of allowed to run with it until sometimes something big happens, and then he oftentimes wants to get back involved. So if you think about the way that the sort of TikTok ban played out, they were looking at banning TikTok, and that was moving along until there was then like sort of the auctioning process where people were involved, and Donald Trump wanted to be very involved in that because he likes sort of making deals and negotiating with companies himself.
What do you anticipate coming up in 2025 as far as any more antitrust cases that may be coming down the pipe?
Yeah, so in addition to the Google case we already mentioned, the FTC's big case against Facebook, which is over whether Facebook should be forced to sell off Instagram and WhatsApp, is scheduled to go to trial starting also in April for about 10 weeks. That one should be very interesting. Mark Zuckerberg, Sheryl Sandberg, and some other very senior Facebook executives are set to testify. And it is is really about sort of fixing what a lot of the antitrust people think is like one of the seminal mistakes of the internet generation, which was allowing, Facebook to acquire Instagram. So it will be interesting to see what the court does there. That one is sort of at the point where it would be difficult for the Trump administration to roll it back because it's already sort of slated to head to trial very soon. But some of the other ones that are pending, as we mentioned, the Apple case, the Amazon case, those are sort of ones that might potentially see settlements.
Interesting that they're mostly big tech.
Yes. This all started towards the end of the first Trump administration. In 2019, the DOJ and the FTC did this big divide where they decided that the Justice Department would look into Google and Apple and the FTC would look into Facebook and Amazon. And right at the very end of the Trump administration, they sued both Google and Facebook. Mm-hmm. And then they sort of turned their attention to the other tech giants, Apple and Amazon, and ended up bringing cases against them in 2023 and then earlier this year. But though that has taken a lot of agency resources because, these are not that large agencies. They only have about like 800 to 1,200 people. And when you're talking about some of the largest companies in the world, it certainly takes a lot of resources to go up against them. So they have these major cases and sort of the outcome is still very much in doubt. Antitrust cases also tend to take a very long time. So even though the cases were originally, the Google and Facebook cases were filed in 2020, we're still here in 2024 going into 2025 and we don't have them resolved. So I wouldn't expect a quick resolution to anything really.
Wow, but it's going to be very interesting to watch.
That's certainly true.
We're going to watch it right along with you.
Keeps me employed, so I don't mind too much.
Well, there's nothing wrong with that either. Well, let's shift gears for a second and move to the FTC. You had mentioned that Donald Trump has already got somebody in line ready to take over and to move into one of the FTC positions. There have been a lot of questions about one of the roles of the FTC. They had tried to do the non-compete clause, put a ban on the non-compete clause. That got squashed. Where is that going to be going now under a Trump administration?
Yeah. So the chair of the FTC right now is Lena Khan. She is expected to step down once Trump is inaugurated, sort of to open up the space for him to nominate a third Republican so that they have a majority. But that oftentimes that process takes several months. So as soon as she leaves, the agency is going to be deadlocked at 2-2 because they have 2 Republicans and 2 Democrats in office right now. That sort of prevents any really major shifts because, if the agency, for example, wanted to withdraw any of these rules, it can't do it without a vote. But these proposals are probably going to end up being pulled back. Both of the Republicans who are on the commission right now voted against nearly all of the rules that have been put in place, including the non-compete ban. One of the Republicans voted in favor of the more recent junk fee rules, so that one might be able to stay. But some of the major ones are probably going to be pulled back, though not until they have their third Republican in place later in the year. That third Republican who has been nominated is Mark Meador. He is the longtime chief staffer for Senator Mike Lee, very well known in antitrust circles. He has made a name for himself representing some of the conservative platforms in cases that they've brought against the tech platforms, including Rumble, which has sued Google over some of the alleged deplatforming that has taken place. That's when they're removed from app stores and things like that. So that is probably going to be a major focus of the next FTC.
All right. Our thanks to Leah Nylen. Thank you, Leah, for taking the time.
Thank you for having me.
She covers antitrust for Bloomberg News. And thank you for joining us on this special edition of Bloomberg Law. I'm Amy Morris, in for June Grasso. Stay with us. Today's top stories and global business headlines are coming up right now.